Welcome to episode 3 of the Succession podcast. An audio-video reviewer on the law on succession based on the book by Paris. This is a continuation of our discussion on Chapter 2. In the previous chapter, we talked about Section 1, Subsection 1. In this episode, we will be talking about Section 1, Subsection 2. Subsection 2 is all about testamentary capacity and intent. Let's begin. In order to fully understand today's topic, we must distinguish testamentary power and testamentary capacity. On the one hand, testamentary power is the statutory right to dispose of property by acts effective mortis causa. In other words, it is the privilege granted by law to someone to make a will. On the other hand, testamentary capacity is the right to make a will provided that certain conditions are complied with. Stated otherwise, it is the ability to make a will. The conditions are as follows. 1. The testator is not prohibited by law to make a will. 2. The testator is at least 18 years of age. 3. The testator is of sound mind at the time of the execution of the will. Again, soundness of mind means that the testator knows the nature of the estate to be disposed of, the proper objects of his bounty, and the character of the testamentary act. Article 796. All persons who are not expressly prohibited by law may make a will. Who can make wills? There are two general qualifications. 1. The testator is 18 years old or over and 2. The testator is of sound mind at the time the will is made. A convict under civil interdiction is allowed to make a will. Even spendthrifts and prodigals are allowed to make a will provided that they are not under 18 years old and are of sound mind. This article should be understood to refer only to natural persons, and not juridical ones, like corporations. Article 797. Persons of either sex under 18 years of age cannot make a will. This article emphasizes the required age for making a will. Article 798. In order to make a will, it is essential that the testator be of sound mind at the time of its execution. Similar to the previous article, this one emphasizes the second general qualification for making a will. Here, it must be noted that the soundness of mind must exist at the time of the execution of the will, not before nor after. Article 799. To be of sound mind, it is not necessary that the testator be in full possession of all his reasoning faculties, or that his mind be wholly unbroken, unimpaired, or unshattered by disease, injury, or other cause. It shall be sufficient if the testator was able at the time of making the will to know the nature of the estate to be disposed of, the proper objects of his bounty, and the character of the testamentary act. The first paragraph gives the negative definition of soundness of mind while the second paragraph gives its affirmative definition. Paralysis, cholera, insomnia, diabetes, sleeping sickness or Addison's disease, cerebral hemorrhage affecting half of the body, deafness, blindness, and poor memory do not necessarily constitute an unsound mind. To be sure, soundness of mind only requires that the testator knows the nature of the estate to be disposed of. The testator knows the proper objects of his bounty, and the testator knows the character of the testamentary act. There are various ways how unsoundness of mind is manifested. Some examples are religious delusion resulting in the unsettling of judgment, blind extraordinary belief in spirits while executing a will, insanity on a single subject or monomania, belief in things which no rational mind would believe to exist, Article 800. The law presumes that every person is of sound mind, in the absence of proof to the contrary. The burden of proof that the testator was not of sound mind at the time of making his dispositions is on the person who opposes the probate of the will. But if the testator, 1 month, or less, before making his will was publicly known to be insane, the person who maintains the validity of the will must prove that the testator made it during a lucid interval. This article provides that sanity is the general rule. Hence, he who alleges insanity bears the burden of proof. If, on the other hand, the testator has been known to be insane, he who alleges sanity must prove the same. It is also important to note that no presumption of insanity arises from the presence of mere delirium or intoxication, since these are temporary in nature. No presumption shall also arise from the insanity of the parents or the children of the testator. Article 801. Supervening incapacity does not invalidate an effective will, nor is the will incapable validated by the supervening of capacity. This article provides for 2 circumstances. 1. Suppose Cece made a will, and later on, she went insane. The validity of her will that she made when she was well is not invalidated. 2. Suppose now that Cece, when insane, made a will, and later on, she became well. The invalidity of her will that she made while insane remains despite her being well. Article 802. A married woman may make a will without the consent of her husband and without the authority of the court. This article is pretty self-explanatory. It must be noted, however, that this provision is without prejudice to contractual succession in a marriage settlement between future spouses. Article 803. A married woman may dispose by will all of her separate property as well as her share of the conjugal partnership or absolute community property. The previous article provided that a married woman may make a will without her husband's consent. This article provides what she can or cannot dispose of in her will. The wife cannot dispose of her husband's capital in her will unless she knows that the capital is not hers, and intends that her administrator or executor will purchase the same from her husband for distribution to the heirs. Also, it is understood that the married woman must respect the legitime of her compulsory heirs. This will be discussed further on the chapter on legitime. We have reached the end of this episode. See you all on the next episode where we continue with the discussion. Please like, comment, and subscribe for more.